Welcome to the latest in our series on lunchtime workouts, intended to give you more tools in your toolbox as we enter into the next few months, if not years, of economic uncertainty. Today, we're going to be discussing the exciting, rare, often misunderstood tool of receiverships. My name is Sabrina Neff. I'm in the Houston office, and I'm a consumer and commercial finance litigator. My job is to turn the screws and get our clients paid, and to vigorously defend lenders in challenges to their rights to enforce loan documents and reach their collateral. We are going to be joined today by Dan McGarry. Dan is in our Madison office, and he specializes in bankruptcy, out-of-court restructurings, receiverships, and collections. Dan is a double threat, licensed in both Wisconsin and Minnesota. Okay, so quickly, receiverships, for those of you who've not worked in this space, they derive from the court's rights sitting in equity. The whole purpose is to preserve the property that's at issue during the course of litigation. But as you will learn, if you haven't already, when you're in a receivership, you are very likely going to be holding the court's hand the whole time. And the party that is both reasonable and knowledgeable throughout the process is the party that the court is most likely going to allow to do what it wants to do in the appointment of a receivership. The states, however, because there is no uniform code among them promulgated for their receivership statutes, they're going to vary based on the situations in which appointment will be permitted and what the requirements of appointment will be. Generally speaking, there are two types of receiverships or two types of receivers. And the reason that comes with an asterisk is that the rules governing receivership and requirements for appointment of receivership vary in both state and in federal court, and derive from rights that are either in common law in the states or in federal common law, or in state statutory rights for receivers themselves. But they fall into two general buckets. In the first are your general receivers, and for those of you in the insolvency space, this looks the most like a Chapter 7 or 11 trustee. They're going to be a receiver appointed over all of the business of the debtor. In contrast, there are special receivers. These are the much more frequently appointed, easier to get appointed receivers, and their job is to take control of a specific line of business or a specific asset. The powers are going to be enumerated in the receivership order, and that's why the language in the receivership order is incredibly important. There won't be statutory general receiver rights for a special receiver. When you're trying to decide what kind of receiver you want and whether you want to fight in state court or in federal court, whether this is a statutory right or common law, the most important determinator of that or factor is what the asset itself is, where it's located, and what the income stream for that asset is. So at the outset, you need to identify the asset you want a receiver over and think through what is the nature of our security interest in that asset. If you're not a secured lender with regard to that particular asset, move on. This is not your tool. But you also need to think about where it's located. For example, if the credit facility at issue is cross-collateralized with properties that cross state lines, you're going to want a federal receiver so that you don't have to have multiple state receivers. Additionally, think through how you're going to capture the income stream for that asset. The income stream for a commercial office building is the rents from the tenants. That is a different kind of income stream than the income stream for a hotel, which comes through bookings. And you need to think through how that money is generated, capture everything that will allow your special receiver to be able to exercise control over that asset. Additionally, you want to think through what potential dangers there are with regard to the asset, either environmental or issues that derive from tort rights. You may need your receiver to take steps to remedy CERCLA issues or to avoid attractive nuisance claims. You may say, but Sabrina, we put a right to a receiver in our loan documents, and that's good. You should be doing that. But whether that's determinative of your client's right to have a receivership depends on the state or the federal court in which you bring that matter. Just off the bat, Federal law does not recognize that consent in loan documents is determinative at all. It's not even an evidentiary factor for appointment of receivership. So it doesn't matter in federal court. In state court, there's three theories. One is that it automatically entitles a receiver to be appointed. That's a minority of states. Another minority opinion is that it doesn't matter at all. But the primary view, the prevailing view, is that consent has substantial evidentiary weight, but it is only one factor that's considered by the court in appointment of a receiver. So if you're looking to appoint a state receiver, you look at what the statutes allow. For example, in Texas, there are 14 different types of statutory receivers, and there are common law receivers. It's going to depend on what state your asset is located in, but all states, or most states, have enacted some sort of statute to permit appointment based on ideas like there's a problem with the dissolution of a corporation or insolvency or fraud. These are very common in most state statutes. In federal law, the rules regarding the appointment of a receiver are much more circumscribed and are found in Federal Rule 66. This creates an unfortunate situation in the appointment of a federal receiver in that most courts treat the appointment of a federal receiver like the requirement for proving up the right to injunctive relief, which is just a very high bar. And I'll show you a little bit more about that in a second. So the factors that a state court is going to take into consideration really fall into three primary categories. They want to know about the party's relationship to the property, including your client or your lender's relationship to the property as a security interest. They want to know what equity or other basis there is, whether it's statutory or common law, for the appointment of the receiver, and they want to know about the qualifications of the receiver. In contrast, in federal court, if you read through this list, it reads like you're preparing for a temporary injunction hearing. And that's what the court is going to treat it as. You will have to prove not only imminent harm, but your probable success on the merits in the case that you bring that will be ancillary to, or that this proceeding is ancillary to. The absolute most common context in which there's going to be a commercial loan in which we seek appointment of a receivership is during the pendency or in view of an anticipated foreclosure. So in lien theory states, which are states where you have mortgages as opposed to deeds of trust, the traditional rule is that if the mortgage or other security agreement doesn't contain consent, the property has to be underwater and the mortgagor must be in default. If the mortgage has consent in it for the appointment of receiver, then you only have to show default. As you know, there's both judicial and non-judicial foreclosure states. So in a judicial foreclosure state where foreclosure will have happened pursuant to an action in court to obtain an order for foreclosure, then an application for the appointment of receiver is ancillary to that action for foreclosure. But in a non-judicial foreclosure state, there must be a separate lawsuit filed. So you're usually filing that in conjunction with a lawsuit for breach of the note or for specific performance on assignment of rent in a provision of a deed of trust, something like that. The burden of proof also varies from state to state. Here are a few examples listed here. Illinois has a really interesting burden shifting provision that's worth a look if you ever find yourself looking for a receiver there. In Oklahoma, you have to prove up both consent of an application for appointment of receiver and a default of the mortgage. In Florida, the primary issue is proving waste. And in South Carolina, you have to show a danger of the property being lost or materially impaired. Just a quick word on the contents of your receivership order. This is the most important pleading you will file in that case, and it's important to get it right. This is the only context in which, as a litigator, I will tell you that more is more. In your order, you should explain why the receivership is needed, You should describe the broad terms of the assets to be included. You need to address the issue of borrowing money by the receiver, and we'll touch on that again in just a second. Whether the receiver can sell the assets, the rights to custody of assets, and how those records will be delivered to the receiver, whether there's ancillary support professionals for the receiver that need to be authorized, how the receiver will be compensated, and the receiver's ability to contract with third parties and utilize the debtor's permits and licenses. If you think through things like receivership over a halfway built condominium building, what all in the receivership order do you want that special receiver to be able to have access to? They need the architectural plans. They need all permits that have already been stamped by the regulatory authorities. They need to be able to contract with or negotiate with anybody who might have been stiffed and filed a mechanics lien along the way. They need to have the powers to do all of those things in order to complete that construction project and turn that into an income producing asset. And the last thing I'll touch on before switching things over to Dan is financing and borrowing. This is a particularly sticky issue in receiverships because unlike in bankruptcy, there's no such thing as the equivalent of DIP financing for a receiver. The critical questions that you need to think through is, does this state law even allow the receiver to borrow funds? And if it does borrow funds, what happens to all junior creditors that are not the creditor who filed the application for receivership? And as is often the case, that creditor who filed that application for receivership advances additional funds for some purpose for the continuation of the business of that asset. If they do so, are all junior lien holders subordinated to that additional extension of credit? These are issues that often create litigation and are things that you probably need to think through on the front end, especially if you know on the front end that there's going to need to be additional financing. So with that, I will turn this over to somebody far better spoken on the issues of bankruptcy. Dan, take it away.
Thanks, Sabrina. So I'm going to touch on a few issues that sort of cross over between bankruptcy and receiverships. And from a broad standpoint, receivers will tell you that receivership actions are faster, better, and cheaper than bankruptcy. And that's true to an extent. But you'll see as we go through these slides that oftentimes the protections that you get in bankruptcy aren't available in a receivership action. So for instance, and so you're looking at basically two flavors of receiverships. You've got a receiver who's actually going to come in, operate the business. It's a going concern. There is some enterprise value there that the secured lender wants to preserve. And so, as Sabrina said, all the bells and whistles have to be in your order to make sure that the receiver can carry out those activities. The other, much more common, is that a secured lender has had enough with the borrower. There isn't an opportunity for rehabilitation. They could file an involuntary bankruptcy, and we'll get into that in a little bit. But the easiest route is simply to appoint a receiver that takes over the operations, winds them down, lays off everybody, and then proceeds to liquidate in a fairly, orderly fashion whatever there is. Sell off the real estate, sell off, in lots, the inventory, and so forth. So that's sort of the broad picture of what kind of receivers you get. For instance, the leasing part, and Sabrina touched on this. And I speak mostly from my position here in Wisconsin and dealing with the Wisconsin Receivership Act. There is no concept of assumption or rejection that's articulated in the Receivership Act here in Wisconsin. In fact, doesn't discuss executory contracts at all. So if you're going to get into that, number one, you're going to have, if you're in state court, there's going to be a learning curve for the state court judge to understand what an executory contract is to begin with. and why it's important for the receiver to be able to assume and assign those contracts, particularly if you have, you know, the vast majority of the collateral or the value of the property is intellectual property. If you can't assume and assign those, you know, there's no value there or very little value. So those are the things you have to think about as you're getting into it, is what exactly is the power that is going to be granted a receiver, uh, and get that in the order. Now, Sabrina mentioned, I think, going into state court with a receiver, you want to make sure, and this is common, I think, in Wisconsin. Well, it's in Wisconsin, common in other states. There is a select few number of people who are identified sort of throughout the state as being accomplished receivers. And they will come into court already having the reputation of being able to successfully run a receivership action. And that gives you a leg up because this isn't their first rodeo. They can explain to the court how they're going to produce the value through this process because they've done it numerous times before. So you have to be very careful about who you select as a receiver because there's a lot of state court judges, and particularly out-of-state court judges in Wisconsin, who've never read the receivership statute, don't understand really the concepts of insolvency and bankruptcy issues. And so, as Sabrina said, there's going to be a lot of hand-holding. So you want to have somebody who's got, you know, the bona fides going in there to explain to the court how you're going to go through this. Can you go to the next slide, Sabrina? So again, in terms of sale of assets, usually that's the sole purpose of having a receiver put in place, and it's usually put in place by the secured lender to liquidate the assets. More often than not, the secured lender is underwater. Their assets are underwater, and so, you know, the unsecured creditors are just sort of along for the ride, but chances of them receiving anything are usually pretty low. It varies from state to state, the power that a receiver has in terms of running an auction or liquidating. But frankly, in Wisconsin, it's whatever you can get a sign is usually how it works. You don't generally run into issues of redemption, although they do exist, because by the time you're in court and you're appointing a receiver, it's usually consensual and the borrower has conceded all of its rights. And so it really goes without a big fight. If you're going in on an involuntary basis, that's something you have to understand and think through as to whether or not that borrower is going to have the right to redeem those assets, redeem that real estate. Theoretically, the receiver steps into the shoes of the debtor. So, you know, what powers does the debtor have after that if they're appointed? Can you go to the next slide, please? Again, it's, you know, you want to have your receivership order as broad as possible, allowing the receiver to carry out, you know, everything necessary to realize and liquidate the property and to, you know, forward those funds onto the secured creditor with anything left over distributed on a pro rata basis. Obviously, the receiver is going to have to go back to court every time they're going to do something major, like run an auction process. But the order is at the beginning, particularly if you're talking about a consensual receivership, it's much more difficult for anybody to come in later, particularly the debtor, and say, I didn't agree to that. So you got to make it so it's clear that the receiver is running the show and has all of the powers that it needs to complete the sale process. Next slide, please. So advantages and disadvantages of bankruptcy, and I'll go through these quickly there. You can see them on your own time. But again, the argument on the part of a receiver is it's faster, better, and cheaper, and in certain circumstances, that's correct. I will tell you that the receivership statute in Wisconsin is exactly 4 pages long. and it's based upon the old Bankruptcy Act. And so there's a lot of concepts and issues that weren't addressed and haven't been addressed in the statute. There's been a push for a number of years to revamp the statute to sort of, given the passage of time, that we should put more things in there that you would expect, say, in a bankruptcy court. That hasn't happened. There isn't a great deal of law that has interpreted the receivership statute in Wisconsin, but there is case law that says that by analogy, you can argue bankruptcy court cases that have been decided to decide, or at least doesn't have precedential value, but to assist the state court in deciding how best to approach an issue that may come up. In Wisconsin, there is no automatic stay as there would be in a bankruptcy against all creditors. Again, I'm only talking about Wisconsin, but I suspect there are other states that have this. Secured creditors can either opt in or opt out of a receivership. So if the number one creditor, the secured creditor, says, I don't want to be a part of this, and I'm just going to take my state court, I'm going to pursue my state court rights and foreclose on everything and sell it, there's really no reason, unless you're anticipating a great deal of equity, there's no reason to pursue an involuntary or voluntary receivership at that point, because the secured creditor doesn't have to play along. The automatic stay does apply to other unsecured creditors, other claimants that are coming into court. So that, assuming the secured creditor is going along with this, and again, I would say 80% of the receiverships filed in the state of Wisconsin are voluntary receiverships, that shouldn't become an issue. Then you have the issue of finality. Obviously, there's a lot riding on the fact that your primary goal in a receivership is to sell assets free and clear. And the big difference between bankruptcy and receiverships is in bankruptcy, you get a 363 sale order, and you have national jurisdiction, and you have the ability to draw in all of the creditors who may have a claim to the assets that you're selling. And so you have a much greater potential for getting these assets free and clear in bankruptcy than you do having a judge sitting in a circuit court in Waukesha County issuing an order saying these assets are being sold free and clear, when you have creditors outside the state who may or may not even have gotten notice of it. So if all of your assets, if you're dealing with a single asset debtor and it's located in one location and there really isn't any argument, there's minor unsecured creditors, but they've already written this off, that's a great thing to have a receiver for. If it's going to be more complicated than that, or you think you're going to have an issue with unknown creditors, unknown lien claimants, bankruptcy may be a better route to go. So the receiver, once appointed, technically, theoretically, under the statute, under this case law, has a fiduciary duty to all of the creditors. Again, how this is played out in Wisconsin is the receiver is put in place by the secured lender for the sole purpose of liquidating their collateral and paying the bank off. The receiver either gets paid on an hourly basis, although those fees have to be approved by the court, but the bank pays the receiver. The receiver pays through the proceeds of the sale. It doesn't make any difference to the unsecured creditors because they're really not going to get anything. But that's typically how that works out. In this situation, if you have a voluntary, oftentimes the bank will direct the debtor, this is who we're putting in place as a receiver. We've used this person in the past. We're confident they can line this up quickly. And again, it stays, if you're the secured creditor filing it, it stays all actions against the estate that have been ongoing, which raises an interesting difference between bankruptcy and receiverships. So you have involuntary cases in which the debtor uh, doesn't consent to the appointment of a receiver and in fact fights it, versus a voluntary where the bank says, look, you either go this route or we're just going to, we'll do something else, but you're not going to get out of this. When you file if you file an involuntary receivership and the receiver is appointed, if you get over that evidentiary hurdle that Sabrina was talking about, and you're appointed over the objection of the debtor, the receiver takes over immediately. In bankruptcy, if you file an involuntary proceeding, the debtor still remains in possession of its assets until there's a determination as to whether or not that bankruptcy filing is appropriate. It's called the gap period. So it's not the automatic stay does not kick in at that point with regard to your request to take over the property. There is still, the debtor enjoys the automatic stay, but the debtor also stays in possession of its property. So it continues to operate its business, and if it's fighting to keep the bankruptcy petition from becoming an actual relief order, that could drag on for a while. And so those are issues that you have to consider. Involuntary bankruptcies can be very messy and drag on for quite a while, whereas an involuntary receivership, if you think you have the evidentiary, standards that you've met, that may be a better route to go. Next slide, please. So again, I think we ran through this before. Ideas of assumption and rejection doesn't mean that that won't happen in a receivership, but those aren't as well fleshed out, certainly as you have in the bankruptcy code. Again, there's no automatic stay with regard to a secured lender who doesn't care to participate in the action. And then you have issues of finality. If you get a 363 sale order from the bankruptcy court, you're usually pretty golden. Receivership sale orders can be challenged. I cite the case in there where an unsecured creditor was allowed to come back into the case after the sale and challenge it. So you've got those issues that you have to consider. Next slide, please. The receiver ultimately is answerable to the court. And so theoretically, everything that the receiver does, even if it's at the behest of the secured lender, has to be approved by the court. It has no authority to force a non-consensual use of cash collateral, for instance, if you're trying to operate the business. But again, if it's a voluntary, more often than not, the debtor's already signed off on those rights. And then again, the issues of the sale free and clear, that last paragraph 5, I think that's probably the most significant thing you have to consider if you're going to go the receivership route, whether or not you're comfortable getting that order from the court that allows you to then turn around and sell those assets to somebody else. Next slide. The next one. So secured creditors basically run the receivership action in Wisconsin. Unsecured creditors, there is no unsecured creditors committee. There is no ability. I mean, you can try and pool your assets together, pool your resources together. But once the receiver is appointed and it's established what the value of their collateral is, and they go through an auction process that's been approved by the court, and there's no collusion or anything like that, the order is approved, the sale is approved, the assets are gone, and the unsecured creditors are sort of left holding the bag. Now in Wisconsin, you have the concept of preference actions, of recovering payments made to the debtor just prior to the filing. The look back period on that is a little longer than what you would get in bankruptcy court, which, depending on the facts and circumstances, may sway your opinion as to whether or not you want to go the route of the receiver versus the route of an involuntary bankruptcy. But those assets can be recovered. Those payments can be clawed back, and then they can be redistributed to the unsecured creditors. So there is so you should be filing. There's a claim process whereby you file claims in the receivership. There's a deadline set by the court, just like in bankruptcy. Again, those deadlines are not automatic like in bankruptcy. They're dependent on first day orders and scheduling orders and so forth. So you have to get into the case and make sure you're paying attention to what's going on. Next slide, please. Yeah, so again, there isn't a great deal of law on preference actions in Wisconsin. That's it's fairly established fraudulent transfer law. Preference actions, not so much. So it's really a question of just negotiating with the receiver to see how little exposure you have, which is not unlike what you do in bankruptcy with a trustee. So it's the same process. Usually you negotiate some sort of allowed claim, and then you wait around to see if you're going to get a check at the end of it all. Next slide. And you have issues with the custodians of assets. It's fairly, I won't say automatic, but it's pretty clear under bankruptcy law that if you're holding assets of the debtor at the beginning of a bankruptcy, those assets have to be returned under certain circumstances. That case law isn't so well developed under state law receivership actions. And so that is, again, another consideration to make if you want to go the bankruptcy route versus the receivership route.